He is currently the serving president of SAFA since 2013. He did not surrender himself but was arrested at his residence. He has known about this pending investigation at least since 2020. He has been in constant communication with the investigating officer and the Hawks. There is a review pending in respect of a search and seizure procedure which was done at the SAFA House offices. There is a pending interdict currently in consideration which tried to block the arrest. He intends pleading not guilty. He strongly believes that this case is merely an abuse of process. We will start with the affidavit for applicant number 1. Whilst the reading of your affidavit, Mr. Jordan, you may stand up for that purpose. When we get to the second applicant, then you may be seated and we will attend to Mr. Neathlin. Thank you. Mr. Nkwashu.
As stated, the application will be by affidavit. With the leave of the court, we request permission to hand in the original while I read the contents of the court into the record.
Thank you. You may proceed.
The original division of Gauteng held at the Specialized Commercial Crimes Court, Palm Beach, the matter between Daniel Alexander Jordan, the applicant, and the state is the respondent. Affidavit by the applicant for bail as under section 60, subsection 11, paragraph B of the Criminal Procedure Act of 1977, the CPA. I, the undersigned Daniel Alexander Jordan, hereby make an oath and state that I'm an adult male African citizen, currently 72 years old, and I'm the applicant to this application. I make this affidavit on my own free volition and have not in any way been unduly influenced by any person. The facts herein contained are said where expressly indicated to the contrary within my personal knowledge and belief and according to the fact. Where I make submissions of law based on the advice of my legal representatives, which advice I believe to be correct. I'm advised that I face charges of contravening section 18, subsection 2 of the Righteous Assemblies Act 1965, fraud and theft. No further details were provided to either me or my legal representatives regarding the particularity of the charges. I have first learned about this investigation since the case was reported in May 2020 in the presence of different media houses at Boyson's police station. I was also informed that the matter was investigated by the Directorate of Corrupt Crimes Investigations, in brackets TPCI, colloquially known as the Hawks. I've also been in constant communication with both the investigating officer and the state prosecutor through my attorneys on record. I have pledged my undivided cooperation and lived up to my pledge. When I was requested by the police to provide information, I did so and even submitted a written statement with supporting documentation through my attorneys on 15 December 2022. Both the state and the police will confirm this fact. On 8 March 2024, the investigating team conducted a search and seizure operation at SAFA House in my absence. I was only informed that they did not search my office, but only conducted a search and seized certain documents and electronic equipment in the office of our Chief Financial Officer, Mr. Gordon, who is in charge in this case. Following the much publicized raid at SAFA House on 5 April 2024, the leadership of Sabaton Association SAFA took a decision and instructed our attorneys of record to challenge the lawfulness and validity of the search and seizure operation through the review process, and the matter is currently pending in the High Court on case number 2024-03575. I've been advised by my attorneys that the pleadings have closed and that the heads of argument are currently being drafted and the matter is hard for a hearing and the definition could read.
This speech
is
based
well
on
aware
the premise that the so-called government
on
of
Thursday,
national
7th
unity
November
will be
2024, my
placed
attorney was
as
contacted by the investigating officer to inform me
our
that there is a warrant for my arrest and that he wanted to have a discussion with me over the phone. Indeed, the investigating officer called me on 11 November 2024 and informed me that he was looking for my phone for arrest on 30 November
Here,
2024
for
at
example, does not
0700
believe
hours in the
that there
morning.
should be minimum wages. It does not
I gave an
believe
instruction in my
affirmative
legal team
action.
to offer my
It
full
doesn't
cooperation
believe
to
anything
the
that the
Parliament
ANC
State.
believes
However, due to the
that
communication
by
from
the
the
same
office of the
token
senior
that the
judge involved in
ANC
interpreting
with
conduct
policies
this
that are
arrest until the
fundamentally
review is
opposed,
regulated,
you look,
I
for
was
example,
advised
at
that
the
both the
Palestinian
NPA and the
issue.
state
That
attorney,
is why the
due to
president
preparing
did
the
not
answers
address
and
the
Affidavit, which is
controversy
due this
because
evening at
he will
300
have
hours
to
in the
answer
evening,
to
and
the
getting
DA
off the matter is
because the
scheduled for 10
policies
a.m. tomorrow,
are
14
radically
November
opposed
2024.
in that regard.
I
So
did
that
not
is
end
the
myself
problem.
in arrest, however, the police came to fetch me at my house and brought me before the schools. All communications between my attorney, the state attorney, and the senior judge were forwarded to both the NPA and the DPCI, and hence I was advised that the application in the High Court would have to take precedence over these arrests. I will consider my position once I would have consulted with my legal team about what has transpired here today.
But in our view, the MK
Previous
is
convictions
coalition
of any
government
cases.
like any
I'm
other
advised
coalition
that
government.
in terms of
It's
section
going to
60,
flow because it is
subsection
founded
11,
on a
capital B
false
of Act 51
premise.
of 1977,
Right.
and
What
I'm
had
about to
happened, the
disclose
ANC
in court,
lost the
any
election
previous
from
convictions or communications that I
57%
may have
was
against.
reduced into
I have no
40%.
previous
Well done.
convictions either in the public or South
And then
Africa
they
or
had to
elsewhere.
hold on to power.
Save for
The
this
only way
reason,
to
I'm
do
not
that
aware of
was to
any
look
pending
for
warrants of arrest
certain
against me.
parties that were willing
I further confirm
to
that I
work
do not
with
have
the
any
ANC.
cases
We were
pending against me in any
who were told they don't want to work with us.
I'm
And the
advised that should I
way
will
called
fail
dogs by
refuse
NLC.
or
So I
fail to
understand
support
that
false
the
information regarding my previous
government
convictions
plans to
or
hold
cases
the
pending against me.
account.
I was guilty of an offense and liable to conviction for a fine or imprisonment for a period exceeding 2 years or both.
That's right.
Further, that my bail may be cancelled and I may be required to remain in custody until my trial is found.
We can
I also been
analyze
advised that
them
by virtue of the fact that the engagements
One of the things that
involve
brings
offenses
those parties
monitored
together
in
is
of
funding.
about
Right,
500,000.
by fund, you are
My
in
bail
control
application
what you
fall
do,
within
control
and
what
to
you
dealt
do,
with in
target
terms of section 6 to
what
subsection
you
11,
weigh. That's one of the
paragraph B,
things that
where it
those
is part
parties
of the
together.
Criminal Procedure
And
Act.
tendency that's made it clear that there are three founding parties.
I submit
It's
therefore that
DA,
it becomes
the
upon me
ANC,
that
and
this
the
evidence is demonstrated on the balance of
considers
probabilities
itself
that
on
the interest
behalf
of
of
justice
the
is my
DA
views on
that
bail.
they have a veto power.
The purpose of the application.
So the other parties
Both
are
these
there,
applications set out
obviously,
facts
employment
demonstrating this
opportunities.
court that is the
Time
seeking
for
interest of
blue
justice
lines.
to
We
bail
have been
rather than
elected
to
for
remain in
years in
detention
Parliament
while
on a
on
mission
trial.
to uplift the
In so doing, I'm advised that section 6 of the Act imposes
most
stringent
important
conditions
is to
for
ensure
the
that
granting of bail where
Section
persons
25
stand accused
of
of
the
offences prescribed
Constitution
into the
is
part of it.
amended so that
Section 6
ultimately
subsection 4
property
to
is going to
6
be
subsection 9 of the
expropriated
Act
without
specifically
compensation.
sets out factors
Which will
which ought to be
benefit
studied by me
everybody.
and considered by this
Now,
court if bail
Sorry,
is
there's
or
another
not.
point that you made.
I shall later deal with this.
Yes, I asked
no
them that
circumstance.
what then would be your
I'm a
plans
South
for
African
holding
citizen, identity number 51090550000. And the serving president of SAFA since the year 2013. I was previously the chief executive officer of
What
SAFA
the
from
EFF
1997
has
to
done
2024.
in Parliament over the
As
past 10
president of
years
SAFA, I
is
had my
anything to
services
go
on
over.
a volunteer basis.
It's a clear indication that as much as numbers are
I
important
offered
to
it on the
politics,
random
EFF
payment
was
once a
able
year, ranging from
to hold
1
this
cent
government
to
accountable
depending on the
right, on so many
performance.
fronts, and they were just alone.
As
Now,
independent
it's
paragraph 1 bar,
It's
2 years
MK,
old,
it's
and I've
ATM,
been born in Port
it
Elizabeth, now
is
to
NCC, and
in the Eastern
AUT.
Cape Province of
All five parties
I'm
were
currently resident
programmed.
number 12 West Road, South Estate, Farrington Street, Morningside, Johannesburg for the past 14 years.
EFF was able
This
to
property
hold
valued approximately
over the
6
past
million
10.
rand.
Then would be.
I'm also the registered owner of housing, Gqeberha, situated number 6 Fifth Avenue, Somerset, Gqeberha. I also live in this house with my wife, with whom we share 2 adult children aged 4 years and 4 years old. This property is valued at approximately 4 million rand. I have household furniture, appliances, and fittings in
What
both
the
houses.
EFF has done in Parliament over the
I
past
have
10
2
years
vehicles, a
is
2011
anything to
Mercedes
go.
Benz, then valued at approximately 500,000 rand, and a 2006 or 2007 BMW sedan valued at approximately 250,000 rand. I do not have family or any financial interest or assets in foreign countries. I also do not have any intentions of relocating elsewhere beyond the borders of RSA. I owe my complete allegiance to South Africa. Due to the nature of the office that I hold, I undertake to inform the state should I be required to undertake any foreign trips and produce my travel itinerary as of my departure every 10 days. The merits. I've been cautioned against disclosing the basis of my defense at this stage, which advice I also accept. For purposes of this proceedings, I have detailed the manner in which I was arrested, paragraph 6 to 12 given above. I was obliged to take this court into my confidence with regard to the merits of the case. However, at the time of drafting of this affidavit, the state had not provided my legal representatives with a copy of the docket or the charge sheets. I have, however, provided a statement on the request of the investigating officer with supporting documentation, the issues that he sought clients told me in 2022 already. From the cursory reading of the warrant of arrest, I intend to plead not guilty to all the charges, and I believe that I will be acquitted because the state has no case forward against me. I am of the well-considered view that this arrest is an abuse of the process because of the pending review application in the High Court as mentioned above. This is so because if the High Court finds in our favor, I would have suffered irreparable harm by this arrest and prosecution, even in circumstances where the state is well aware of the pending review application, but still elected to arraign me on these charges. The provisions of Section 6, subsection 4, paragraph 8, read with Section 6, subsection 5 of the Act. There is no likelihood that my release on bail will endanger the safety of the public or any person, or that I will commit a Schedule 1 offense. At the age of 73, I have no previous convictions and no pending case against me. I am not a violent person, and the offenses for which I will be charged do not involve any degree of violence or threat, implicit or otherwise thereto. Section 60, subsection 4, paragraph B, versus Section 60, subsection 6 of the Act. I have strong emotional, familial, and community ties within the Republic of South Africa. As indicated above, I'm married and have 2 children who are adults. I'm a well-known person in South Africa, for RSA. I've been elected and assigned a lot of responsibilities by SAFA on behalf of the people of South Africa. Therefore, I do not intend to jeopardize my repute or status by evading my trial or doing anything that is likely to interfere with the prosecution of this matter. As stated, I have known about this investigation against me for the past 5 years, and I have cooperated with the Hawks. I have not attempted to flee as I believe in my innocence. For this reason, I have fully cooperated with the investigating officer and handed myself in for arrest after the state contacted my attorneys to the point. I trust and have confidence in the South African legal system and firmly believe that everyone deserves to be treated in terms of the rule of law. I did not commit the offenses for which I am accused of for many years. I undertake to comply with any bail conditions pending the finalization of this process. I submit that it would be unthinkable for me to evade my arrest, and doing so will adversely affect the people I serve love and my responsibilities which have been elected and entrusted by the people of this country and South Africa. I respectfully submit that the facts set out above support my contention that I do not constitute a crime and that I have no reason to stand my trial.
Will be in place for the next 5 years. In our view as the MK party,
I am confident that the state will dismally fail to prove the case because there will be no objective evidence that will support
so
their
many
case.
issues. If you take the ANC and the DA, right, the DA, for example, does not believe that there should be minimum wages, it does not believe in affirmative action, it does not believe in anything that the ANC
I'm
believes
uncertain
in.
whether I know that
And by the same token, if the ANC with policies that are fundamental,
I can only presume that these
for
charges were made by
example,
the
the
Islamic
Palestinian
Palestinian
issue. That is why the
I have
president
not
did not
yet
address it. He
provided
can't
convinced
address it
witness
because
by
he will have to
That
answer
notwithstanding,
to
I
the
hold no
DA
resentment to
because the
state.
policies are
I
radical.
have no intention to interfere with or
So
intimidate
that
any
is
of them, directly or indirectly, and I undertake not to do so. I also undertake not to communicate with any witness, whoever he or she may be, and any other persons whose names may appear on the list of state witnesses to be provided by the state. I maintain good relationships with people, and I bear no grudges against anyone. I will comply with any bail condition in this regard. I I have no knowledge of any evidentiary material which may
In
exist
our
with
view,
regard to the allegations
the
thereof.
MK, this coalition
In any event,
government,
I
like
believe that whatever
any
such
other
evidence may
coalition
be,
government,
is in the
is going
position of
to
the
blow
police.
because it is
Safety
founded on a
secure,
false
and I think that
premise.
access there.
Right. What had happened
Stated
is
elsewhere,
they lost the
the
election
police conducted the
from
raid at SAFA House,
57%
and they did not
Ramaphosa
search
reduced it
markets.
to 40%.
Besides,
Well
the
done.
advisor of the investigations are
And then they had to
and hence the
hold
state
on to
applied
power.
and granted
The only way to do that was to look for certain
the
parties that
circumstances
were
submit
willing
that there is no
to
likelihood
work
of
with
an
the
attempt
ANC.
to
We were
influence
instructed,
intimidate
we were
witnesses
told they
or
don't
to
want
conceal or destroy
us
evidence.
and the EFF were even called
Section 6,
dogs
subsection 4,
by
subparagraph
NNC.
C,
So
Regular
having said that,
subsection
you
8
will
of the Act.
definitely then have.
As I alluded to also in this, I still regard myself as a permanent member of the society. I've been aware of the investigation and possible prosecution since early May 2020, and I've done nothing to suggest that I will undermine the proper functioning of the law or jeopardize the investigation or disrupt the
We
public
can
order.
analyze them
I'm always
and
waiting for the legal process to take its
one
course.
of the things that brings those
Accordingly, I
parties
respect
together
this
is
agreement.
funding.
I believe
Right?
that
If I fund,
I
you
release
will
or not
control
disturb the
what
public
you
order
will control
to
what
undermine
you
the
eat,
functioning
control
of the
what you wear. That's one of the things that put those parties together.
Section 6,
And
subsection 4,
it has
subparagraph
made
3,
clear that there are
Section
three
6,
founding
subsection
parties.
8,
It is the DA, it is the
I'm
ANC,
advised that the
and the
consideration
INP.
under these subsections do not
Considers
arise
itself
from bail
on behalf
application
of the
related to the
DA,
part.
that they have a veto power.
Section
So
6,
the other
subsection
parties
9
out
of the
there,
Act.
obviously, is employment.
I'm advised that due to
opportunities,
the fact that this
time
matter
for blue
involves more than
lines.
one
We
accused
have
several
been
times,
elected to our
it is
here
likely to take considerably a long
mission
time before
to
it's done.
uplift the poor,
Need
to
to
work
expand
for
the
poor,
qualification
but
of the
most
police.
important, to
From
ensure
the
that
granted bail on
Section
SAFA subject
25
to prejudice
of
on
the
my
Constitution
detention
is
is allowed.
amended so that
In all
our
likelihood, there may be
property
thousands of
is going
documents
to be
involved in this,
expropriated without
including the ones that are
compensation,
submitted to
which
the
will
courts.
benefit everybody.
Accordingly, keeping me in custody will also hinder me
Sorry,
from
there is
preparing
another point that
for the
you
trial
made.
adequately.
Okay.
I'm advised that the state has no intention to oppose my appeal with bail.
Your plans
I will comply with any condition that this court may
opposition, but I understand
I
that
accordingly submit that the interests of justice, consideration of prejudice, and the balancing of respective interests from my religion, the refusal of bail can only prejudice
What
me
the
and place no
EFF
benefit.
has done in Parliament over the
On the
past 10
premises, I
years
submit that I
is
made out the
anything to
proper
go
case,
by. It's
indicate
a
that
clear
it is
indication that as
in
much
the
as
interest of
numbers are
justice to
important
release
in
me from bail.
politics, EFF was
Should
made
this court consider to
to
release
hold
me on
this
bail,
government
and raise an
accountable
amount of 10,000 naira to
on
post
so
on
many
bail,
crimes
I
that they
cannot
were
afford
just
to
alone.
keep it same.
Now it's EFF,
Wherefore, I will pray that this court
MK,
will to
it's
bail in the
ATM,
appropriate amount.
it is
Such conditions as court will
NCC
be
and AUT.
There is a
All
problem
five
with
parties were in program.
Commission by commission of oath. There are several annexes of communications between the offices of
CFF was able to
our
hold
office as well
over
as
the
the high
past
court.
10
then of opposition party. What can we have
States,
Party what can we
form part of
party what
the
opposition
offices
party
that are prepared to the Affidavit. A person who should accept this
co-cabinet of opposition party.
as an exhibit of
What can we have to hold accountable?
Thank you, Mr. Nkoshin.
what the EFF
Thank you, Mr. Jordan. Did you understand the content of the affidavit read into the record on your behalf?
Yes, Your Worship.
Do you confirm each and every fact contained therein to be true as well as accurate?
Yes, Your Worship.
Thank you. The affidavit in support of the first applicant's application for bail is received and marked Exhibit A to the record.
To the court, please.
All right. Thank you, Mr. Jordan. You may be seated. All right. Thank you. You can stand up. Judgment extempore. The three applicants appear before court on what has been identified as a bail application that resorts within the ambit of Schedule 5. Section 60, subsection 11B of Act 51 of 1977, the Criminal Procedure Act, requires of the applicant to adduce evidence to satisfy that the interest of justice will permit his or her release on bail. The court has attentively listened to the supporting affidavits by the three applicants individually, received as Exhibits A, B, and C respectively. In a summary fashion, they detail the following. The first applicant is a South African male person, 73 years of age, married with 2 adult children. He has known about this pending investigation at least since 2020. He has been in constant communication with the investigating officer and the Hawks, and he has cooperated throughout. There is a review pending in respect of a search and seizure procedure which was done at the SAFA house offices. He did not surrender himself but was arrested at his residence. There is a pending interdict currently in consideration which tried to block the arrest. He has no previous convictions or pending cases. He is currently the serving president of SAFA since 2013. There is no salary income expectation to this, although he does receive a once yearly honorarium payment. There are assets, fixed as well as movable. He resides at the stated address in Morningside, Johannesburg. He has no interests or family ties beyond the borders of South Africa. Pertaining to the merits, he indicated that he intends pleading not guilty. He strongly believes that this case is merely an abuse of process. He, in general, intimates that he will not jeopardize the criminal justice and bail system in general, and he indicated that he has bail in the amount of 10,000 Rand available. Mr. Malabate has gone through the individual applicants and the reasons which they followed up and why they are not opposing the application. In general, I think it suffices to say that all the personal particulars have been verified, confirmed, and found to be positive in respect of all three of the applicants. In general, the respondent indicates they are not considering any of the applicants to be a danger to society or harbor any fear of absconding or not standing their trial. They do not consider them being a flight risk. However, they have requested the court to consider certain conditions pertaining to bail. Pertaining to the surrendering of the passports, it appears from what Mr. Malabate addressed the court, it is more a proactive safeguard than anything else. They also think that they can curtail any possible contact with the witnesses through bail conditions by including a list of which we now know are 19 names contained on which the applicant should not make contact to. Then there was only the slightly higher bail quantum in the amount of 20,000 Rand which the respondent has suggested. Now, after all considered, the court is satisfied that indeed there is no reason to conclude anything other than the interest of justice will permit your release on bail. Pertaining to the quantum, first of all, I do not think that the quantum of bail suggested by the respondent is unreasonable. It appears to be achievable by all the applicants. When considering a bail quantum, the court must not fix bail in an amount which is totally beyond the reach of an applicant, which will tantamount to a denial of bail. But I do not think we are in that ambit. All three of the applicants can achieve the quantum of 20,000 Rand. And as said, I don't think that is an unreasonable amount. The court will fix bail in the amount of 20,000 Rand for each of you. Then pertaining to the surrendering of the passport, we have canvassed this at length. applicant number 2 and 3, your traveling is much more restricted. There's not such a severe need for you to have your passports. So for that reason, I'm going to make a bail condition pertaining to your handing in of the passport or surrendering it to the investigating officer. I will explain in more details the wording of that condition in a few seconds. Pertaining to Mr. Jordan, applicant number 1, currently as the serving president of SAFA, you do have duties in order to travel, which requires traveling beyond the borders. This may change, and the wording of my bail condition that I have worded, I think will address that should there be material changes in your presidency or your position held at SAFA. We will deal with it at the opportune moment. But we need to deal with the situation as it currently stands. For that reason, I will allow you to retain your passport, and I will include some conditions in order to try to address whatever fear the state may possibly harbor in being proactive in monitoring your movement. So, gentlemen, you will be detained in custody until you have paid the quantum of bail, which is then fixed in the amount of 20,000 rand each. Thereafter, you will be released to appear on the first of those dates will be the 5th of December, 5 December, Court 9. Towards your left-hand side, the same passage, 1 court to your left-hand side. 8:30 is the time to remain in attendance until excused by the court and the court only. If you fail to appear or remain in attendance, a warrant will be authorized for your arrest and the bail money will be forfeited to the state. Your legal representative cannot excuse you from attendance. It's only the court that can do so. Please understand that. While I'm on that aspect, Mr. Jordan, any travels of which I'm going to discuss in a moment now, you need to make yourself available for court appearances. If that means you cannot attend a trip representing SAFA, unfortunately that is how it's going to be. You have your co-accused and the state that are all being prejudiced if you are absent because of an out-of-country trip. So this is the condition of why I will agree to releasing and allowing your passport to be with you. Then, pertaining to the bail conditions, applicant number 2 and 3, you are to surrender your passports then to the investigating officer for the duration of this case being enrolled. If and when the need arises to travel beyond the borders of South Africa, you can then approach the court, not the investigating officer, the court, for such a bail condition then to be considered and possibly amended. Such travels, gentlemen, are to be reserved only for emergencies and, if unavoidable, to earn a living. It is not for holidays and for other non-work or emergency-related reasons. Applicant number 1, you may retain your passport. You must provide the investigating officer with a written itinerary of your departure flight, your return flight, and your destination at least 72 hours prior to your departure. It must be in writing. This or these travels must be limited for official duties affiliated to SAFA only. If your position in SAFA changes in future, this bail condition will then be revised. Applicant number 1, 2, and 3, You have received a list of the 19 names of potential state witnesses that appear on that list. The directive and the bail condition is that you may not directly or indirectly make or attempt to make contact with any of these witnesses for any reason whatsoever. That contact, directly or indirectly, is any thinkable or unthinkable method of contact. If you, for whatever strange reason, see one of these people on the list approach you in the mall or wherever you are walking, please turn and walk off. I will excuse your conduct on your behalf to them if they feel offended because you did not greet them. Understand? Please avoid any such temptation, because if the state comes with an application that you have failed to comply with this bail condition, I promise you I'm going to play it safe. Do you understand what I'm saying? So, those are your bail conditions. Do you understand that, Mr. Jordan? Thank you. Mr. Neethling, do you understand? And Mr. Thuyo, do you understand? Thank you. That concludes our application. Thank you.
As a practice, Your Worship, it appears that was the last matter on the court floor, and that would be the roll for the court for the day. May the court adjourn.
Thank you very much, sir.